Good afternoon, everyone, and welcome to our next webinar. This one is extremely interesting topic for us in the ship recycling industry. And to be frank with you guys, I've been doing this for about 2 decades. I don't think there is anything that has come that is as important or something that has affected ship recycling the way the regulations have had an impact on this. Most of it has been good. Some of it has not been very good. So let's get started on this, what we're going to talk about today. And if you can start with the first slide, what we have done is we have put the slides up for you guys. So as we speak, you can follow some of the things we're going to say. And after we finish our presentations, we're going to have a lot of time for Q&A. So most of you are now familiar with the regulations impacting ship recycling. It's not moving. More than 11 years ago, IMO created guidelines for safe and environmentally sound recycling of ships, which led to the adoption of the Hong Kong Convention in 2009. The conference that created this convention was attended by 63 countries. So this happened 11 years ago. Most of you are aware of the Hong Kong Convention. We call it the HKC. 4 years later, the EU came up with its own ship recycling regulation, which was adopted in 2013. And the reasons why EU came up with these regulations were mainly that at that time, Hong Kong Convention was still not in force and was only voluntarily implemented by the industry. Therefore, a regulation, namely a legal tool, was needed to enforce safe and environmentally responsible recycling. That made sense. A lot what that EU did, of course, was borrowed from this. Dr. Michaelis is going to get later on the details of this regulation. The second reason why this regulation, there are many reasons, I'm just talking about the 2 key ones, was that EU ship recycling would replace the arbitrarily used and what was an inappropriate EU waste shipment regulation. The waste shipment regulation, as most of us know, did not apply to ships, yet for lack of a better regulation, it was being used arbitrarily by some of these ports, normally on the behest of, someone complaining to the port, and then the port would have to take action. As part of this implementation of the above regulation, the EU created the European list of ship recycling facilities, thereby giving the impression that EU-approved facilities are better than the Hong Kong Convention facilities, in that they are safer and greener. And most of us in the industry, or most of not us, but a lot of people in the industry believe this to be true, that facilities that are approved by EU are better facilities. They are safer and greener than the Hong Kong Convention facilities. But the main question is, but are they? And we'll discuss a little bit about this during these discussions. As we move on, we know most of the audience here probably knows that EU ship recycling regulation has polarized world perceptions of ship recycling based on inadequate and often biased reporting, but unfortunately by a well-funded tribe of highly vocalized band of prejudiced campaigners. We have been involved with this regulation for a long time, and Dr. Michaelis, again, I don't want to take away from his presentation. He will speak on this, how this regulation came about. But this has caused unnecessary fear and confusion in the minds of sellers. As a consequence, some owners have paid to have their ships recycled in Europe. And we have some examples. The very first example was the Concordia, where if you look at the headlines, the sellers had to pay about $115 million to get the ship recycled in Italy. This is followed recently by another headline where the Costa Victoria was also put up for scrapping in Italy. I don't know exactly how much money that the sellers had to pay to this yard, but these are examples of ship recycling where the sellers have to pay. Whereas the others had to pay about 50% of the value, had to sell the vessels at 50% of the value that you would get in a Hong Kong compliant yards in the Indian subcontinent. So this is some of the repercussions that has come out of this EU ship recycling regulations. One disclaimer, one point I need to make right away is as cash buyers, it does not matter to us if an owner wants to recycle their ship in Europe, the United States, or anywhere else. Because often there's an impression that we are fighting for the Indian subcontinent and not for the Turkish yards. It doesn't matter. We have sold ships to Turkey, and we used to sell ships in China when China was recycling. So we are the intermediaries. We don't care. If you ask us to sell your ship in Mexico, we'll try our best to find your yard in Mexico. So as cash buyers, our customers also include these yards in Europe. Therefore, our intention is only to highlight the facts and not to criticize the yards or the decision that owners make on where they wish to get their ships recycled. Again, I highlight the fact that we are not yard owners. We are simply the cash buyers. To shed further light on these issues, I'm truly delighted and truly privileged to have with us Drs. Michalis and Dr. Anand Hiramat with us. Between the two of them, I often call them the dream team. Those of you who are not familiar with this American slang, this is the famous basketball US team that was put together for the 1992 Olympics. And the media called it the best sports team ever assembled. So that's quite a compliment, but I mean it in all honesty. Let me talk about my first speaker a bit. He needs no introduction. He's a very familiar face. He has been in the ship recycling scene and on the IMO scene in the past life for more than almost 2 decades. He has worked extensively away from this industry. He worked for a ship owner, he worked for IMO, and now he's an independent consultant and a non-executive director at GMS. He's passionate about ship recycling, even though he has been a bureaucrat and a technocrat, and he felt compelled to take time and write 2 books, which he has published, The Recycling of Ships. These books are available on our website. If you don't have access, please let us know and we are happy to send them to you. You can download the e-version of it, or if you prefer, we can even courier you the hard copies. I would ask you to please go and look at his bio if you want to know more about him. It's again on our webinar, and to know more about Dr. Michalis. Briefly about Dr. Anand. He's another extremely qualified person. He has a master's degree in environmental engineering and a doctorate in ship recycling, perhaps and one of 4 in the world who has a doctorate in ship recycling. And this is from India's premier technical institutions. He joined GMS in 2015, and he created the industry's first and only responsible ship recycling program. This program has been vetted by industry peers and has been the winner of the Sea Trade Green Shipping Award in 2018, and has been finalist in the Lloyd's List Global Environment Award in 2018 and the Maritime Standard Green Shipping Award in 18 and 19. I say this to show that this is a program that has been vetted. We are not just saying we are great in what we do. It's the industry peers who have gone in and looked at this program and given these accolades. So under this program, we have already recycled 63 ships under the guidelines of the Hong Kong Convention. And the interesting thing is that GMS Responsible Recycling Program is the only India-based program that has been vetted and approved by leading ship owners who have traditionally depended on auditors from Scandinavian and European countries. They still do, but this is another extra benefit. We are based in Alang, where recycling is conducted. He also has published, and he has published the Green Handbook, and that's also available, that talks about what we do and how we do it. So it's out to the world to look at it and study it. And since this book has been published, I have not received one negative comment on it, only positive comments. So I invite you to look at this book as well. Dr. Anand is also a course director at the Lloyd's Maritime Academy. He's now joining us from India. By the way, Dr. Michalis is joining us from his office in London. Once we talk about these regulations, it's still important to understand what are the implications of these regulations. Why do we see so much negative material being written about this regulation, and including some of the prosecutorial risks that we find in this industry? So we have a bright young man, Mr. Nelson Chang, to talk about these aspects, the legal aspects, then the ESG risks, the CSR risks, the headline risks, and what are some of the reasons why we find, ship owners find, and they find their ships in the headlines. While it is unreasonable to provide a silver bullet answers to this evolving body of law, Mr. Nelson Chang, who also joins us from Dubai, has studied this issue closely from both this headline and prosecutorial risks perspective. He will address some of the trigger points for litigation in the past and the proactive steps that ship owners and other stakeholders may consider taking when selling their ships for recycling. So Nelson is a qualified lawyer from South Africa who has worked for major ship owners and a global law firm before he joined GMS. In his short time at GMS, Nelson has dealt with several of the issues that have had a consequential impact on the industry. Once we are done with that, I'll bring two other GMS team members on the panel. One is again, Mr. Arjun Mittal, our lawyer from India. He works closely with the yards in the Indian subcontinent and the regulations that impact from the yards perspective. And most of you know probably our senior trader, Jamie Dalzell, who comes to us from his Singapore office. Once we finish the presentations, we'll try to limit this within 1 hour. We will come into the Q&A sessions to give you enough time to ask questions. But before I turn over to Dr. Michalis or any of the other things, I've taken the liberty of doing a very short poll so that I understand the pulse of the audience. This poll has only 5 questions. I request you guys to just do that, fill up these questions so that we have a perception of what you feel about the industry. Once we collect the results of this poll, we will then publish it during the Q&A session. So I'm gonna pause for about 5 minutes while Dr. Michalis gets situated. And please, if you would, kindly participate in this short poll. Thank you very much, everyone, for participating. I'm gonna turn over the screen to Dr. Michalis. Dr. Michalis, if you would take it over, please.
Thank you, Dr. Sharma, and good morning, good afternoon, good evening to the audience. In the next 22 to 23 minutes, I will use 20 slides to give an overview of the international regulations that are currently enforced on ship recycling, to explain the circumstances that these regulations may apply, and to point out some gray areas in their enforcement. The following are the relevant conventions regulations that may apply to ship recycling. Basel Convention, the Ban Amendment to Basel Convention, European Union Waste Shipment Regulation, Hong Kong Convention, which has not yet entered into force, and the European Union Ship Recycling Regulation. The Basel Convention was the first attempt at regulating the recycling of ships when they tried to implement an off-the-shelf, already in force convention. This convention was developed under the aegis of UNEP to combat toxic trade following the discovery in Africa and some other parts of the developing world of toxic waste imported from abroad. The convention was adopted in 1989, entered into force in 1992, and currently has 187 parties, which is most countries in the world, with a notable exception of the USA. The objective of the convention is to protect human health and environment from the adverse effects of hazardous wastes. It aims to minimize the generation of hazardous waste, to treat and dispose hazardous waste as close as possible to where they are generated, and to minimize international movements of hazardous waste. Note that none of these aims appear particularly appropriate or relevant to the recycling of ships. The Basel Convention allows the transboundary movement of waste if this represents an environmentally sound solution, and if the principles of environmentally sound management are observed, and if it is carried out in accordance with Basel Convention's regulatory system. The regulatory system is centered on the concept of prior informed consent, which requires the authorities of the state of export to notify and to provide detailed information on the intended movement to the authorities of the state of import and to any transit states. The movement may proceed only when all these states have given the written consent. This can take considerable time. The ban amendment came in a further effort to strengthen the protection to developing countries when in 1994 parties to the Basel Convention adopted the amendment which bans the export of hazardous waste from OECD to non-OECD countries. The ban amendment entered into force very recently in December 2019 and currently has 99 parties. The European Union Waste Shipment Regulation, it's the implementation by the European Union of the Basel Convention into European law. This happened in 1993. In 2006, however, the European Union replaced its earlier implementing regulation by the Waste Shipment Regulation, which additionally and unilaterally implemented the ban amendment forbidding the export of hazardous waste from member states of the European Union to any developing, that is, non-OECD countries. At the end of the 1990s, parties to the Basel Convention considered that the convention should regulate the dismantling of end-of-life ships. As the Basel Convention contains no practical provisions for regulating this activity, its parties developed and approved in December 2002 voluntary guidelines, that is, non-mandatory guidelines. However, the Basel Convention had not been developed for regulating end-of-life ships. Not only does it not address the issue of workers' occupational safety at all, but importantly for its enforcement, it is ignorant of the governance structures of international shipping. The flag of the ship, the nationality or location of the owning or managing company do not appear anywhere in the convention. Instead, its enforcement is triggered by the export or intention to export a ship from a party to Basel Convention for recycling. Nevertheless, a ship owner who is aware of the requirements of the convention may have ample opportunity to ensure that the ship's last voyage is not considered to be a bounded transboundary movement in accordance with the Basel Convention, for example, by not declaring or making known the intention to recycle the ship until she's in the high seas or in the waters of the recycling state. From quite early, it became evident that there were practical and legal difficulties in enforcing the convention to ships. Because of the difficulties in enforcing the Basel Convention on the recycling of ships, the 7th Conference of the Parties to the Basel Convention in October 2004 decided to invite IMO to consider establishing mandatory requirements for the recycling of ships that would ensure an equivalent level of control as that established under the Basel Convention. That's a well-known decision of the Conference of the Parties. IMO's 24th Assembly in 2005 adopted a resolution that instructed its Marine Environment Protection Committee to develop a new legally binding instrument on ship recycling. Work started in March 2006, and 3.5 years later, the draft text of the new convention was submitted to a diplomatic conference convened in Hong Kong from 11 to 15th of May 2009. Representatives from 63 member states, 2 associate member states, from the secretariats of the Basel Convention of ILO, and observers from 1 international governmental organization and 8 NGOs attended the diplomatic conference. The conference unanimously adopted the final text of Hong Kong International Convention for the Safe and Environmentally Sound Recycling of Ships, 2009, which is the full title, also known as the Hong Kong Convention or the HKC. The text of the convention also makes reference to 6 guidelines that were developed by IMOs and EPC in the 3 years following the adoption of the convention. Although guidelines are non-mandatory texts, they provide clarifications, interpretations, and uniformity of implementation and enforcement of the relevant requirements of the convention. The convention applies to all ships flying the flag of a party except ships below 500 gross tons, government-owned non-commercial service ships, and ships that are operated throughout their lives exclusively in domestic waters. The key elements of the mechanisms underlying the convention are the following. Inventory of hazardous materials that applies to ships. International certificate on inventory of hazardous materials that the ship has to obtain after survey. Ship recycling facility plan that applies to the ship recycling yards. Document of authorization to conduct ship recycling which applies to the yards. Ship recycling plan which is created by the yard but on the basis of the information of the specific ship it is to be recycling. And also various notification requirements, port state control, ability of a ship flying the flag of a non-party state to be recycled in a yard at a party state as long as that ship meets the requirements for IHM. And conversely, inability of a ship flying the flag of a party state to be recycled in a yard of a non-party state, although such a ship can always change flag to a non-party flag and go to a non-party state. The convention will enter into force 24 months after 3 conditions. First, it has 15 contracting states. 2, the fleet of the contracting states is at least 40% of the world's gross tonnage. And 3, the recycling capacity of the contracting states in gross tons is at least 3% of their fleet's GT. So far, 15 countries have ratified Hong Kong Convention, whose fleet is 30% of the world's fleet and whose recycling capacity is 2.5% of the required tonnage. The current impediment to entry into force is the missing recycling capacity, as there are plenty of countries with large fleets willing to ratify, but who have been convinced to wait so as not to add too much tonnage that would proportionally further increase the recycling capacity requirement. For over 20 years, just 5 countries, Bangladesh, China, India, Pakistan, and Turkey, have been recycling 97 to 98% of all the tonnage that is recycled in the world. From the end of 2018, China banned the imports of ships for recycling, and therefore, for the time being, the world ship recycling industry is dominated just by 4 countries. Turkey and India are already contracting parties to Hong Kong Convention. Bangladesh brought a new Parliament Act on ship recycling and intends to accede to the convention by 2023. Before then, China's accession can bring the convention into force thanks to the way the convention calculates ship recycling capacity, which is the largest tonnage recycled any year of the last decade. As China in 2012 had a record year, it can still contribute its nominal capacity and therefore with its own fleet and the fleet of Hong Kong and could fulfill both conditions. The shipping industry, and by now most of the ship recycling industry, have recognized the value of Hong Kong Convention as a necessary, realistic, balanced and practical international convention that will improve standards where they are most needed. However, there is a continuing dissent and opposition to the convention from an organization called NGO Shipbreaking Platform. This is because Hong Kong Convention has not banned the beaching of ships in tidal conditions, and in this way, it has not kept India, Bangladesh, and Pakistan out of the scope of the convention. And the photograph shows a demonstration outside the Hong Kong Convention Exhibition Center by the platform on the day of the adoption of Hong Kong. Coming now to European Union ship recycling regulation. The European Commission calculated in 2009, 91% of European end-of-life ships had avoided or evaded the provisions of its waste shipment regulation. Rather than wait for Hong Kong's entry into force, and instead of offering any kind of assistance to the countries of South Asia that recycle most of the world's standards, the Commission decided to develop its own ship recycling regulation. Following the developments of the first draft by DG Environment of the Commission that contained several naive and ill-advised concepts, negotiations between European Union member states, especially during the Cypriot presidency, resulted in text that mirrored all the requirements of the Hong Kong Convention. Following further and highly politicized negotiations between the Council and the European Parliament, some minor changes were introduced, which at the time looked as non-controversial. Later, the interpretation of these changes were used to justify demands for a ban on beaching. Otherwise, all the mechanisms and requirements of EUSRR are replicating HKC, except of 1, the inclusion of 2 additional hazardous materials to be controlled on EU flag ships, and B, a different mechanism for approving recycling yards. The EUSRR, each EU member state authorizes the operation of yards in its jurisdiction. On the other hand, as the regulation is not an international convention, the EU does not have the power to enforce its own requirements on yards that are located outside the EU, and for that reason, yards located outside the European Union, wishing to be included in the European list of approved facilities, are required to apply and to be approved by the European Commission, following audits by the Commission and or its consultants. The EUSRR entered into force 30th December 2013, but its implementation, which is called date of application, started in stages. From the end of 2016, the first version of the EU list of approved facilities had to be published. From the end of 2018, all EU flagships going for recycling had to fulfill the requirements of the EUSRR. And from the end of 2020, all EU flagships in operations will have to be certificated that they have a valid IHM, an inventory of hazardous materials, as will also ships flying other flags if calling at a port or anchorage of the EU. Currently, in July 2020, the EU list of approved yards contains 34 European yards, most of them only capable to recycle boats as opposed to ships, 1 yard in the USA and 6 yards in Turkey. It has been argued by international shipping and ship owners associations that this capacity is grossly inadequate. In response, the Commission has stated that the capacity is adequate. Nothing could be furthest from the truth. The fact that this very little ship recycling activity has often been explained in terms of the inability of Europe to compete with low labor costs and low compliant costs of South Asia. However, the reason why ships are not recycled in Europe lays elsewhere. Whereas the Asian countries import large quantities of scrap steel for the needs of their domestic economies, Europe is the world's largest net exporter of scrap steel. Therefore, the idea of setting up a ship recycling industry to break ships with considerably higher labor and compliance costs in order to export the scrap steel to Bangladesh or India is simply not credible. 20 Indian yards have applied to be included in the EU list. They are all yards that have upgraded their facilities to fulfill and for some yards to exceed Hong Kong Convention requirements, as attested by IA-class societies. Nevertheless, none of them has been approved so far. Until recently, the lack of approval was mainly attributed to lack of adequate medical facilities for dealing with major accidents in the hospital near the yards and the 1.5 hours drive to the nearest major hospital, although such a requirement does not feature in EUSRR, and also to the provision of incomplete information on downstream waste management for certain waste streams. However, more recently, the Commission appeared to be blaming the entry into force of the ban amendment in December 2019 as legal reason for not approving non-OECD yards. I should have stated that yards in Turkey is an OECD country, therefore yards in Turkey are approved, are OECD yards. To some, this may sound as a lame excuse, as the EUSRR explicitly allows the exclusion of ships that fall under its scope from the provision of the waste shipment regulation. Now, looking at prosecution on ship recycling issues. To my knowledge, there have been 3 prosecutions in Europe for illegal export of end-of-life ships under the waste shipment regulation, 2 of these in the Netherlands and 1 in Norway, and none so far under the EUSRR. Sea Trades was the first. In 2012, ship owner Sea Trade sold 2 ships for recycling in Turkey, 1 ship in India and 1 ship in Bangladesh. For the ships sold to Turkey, the waste shipment regulation had not been followed, or the procedures had not been followed. The prosecution proved that the decision to send the ships for recycling had been taken before departing the EU ports. The court imposed a 12-month suspension on each of the 2 directors, together with fines of €750,000, and acquitted a 3rd executive. The suspensions were given in lieu of prison sentences, which the court noted were warranted on the facts, on the basis that this was the first case of its type to be heard by a criminal court. Note that waste shipment regulation has criminal. Interestingly, in 2020, in July 2020, the Hague Court of Appeal disqualified the guilty verdict of one of the judges as not impartial and has ordered a retrial. I don't expect that the retrial may come to a different outcome, but we shall see. Second recent case was the HMS Lawrence. In 2013, a subsidiary of WEC Lines BV in Netherlands sold the HMS Lawrence for recycling in India. In January 2019, following criminal investigations on the illegal export of the vessel from Italy to non-OECD recycling country, the Dutch public prosecutor agreed to a settlement of 2.2 million, which was the amount the owner had earned from the sale. The ship owner was also fined €780,000. The prosecutor stated that he had accepted the settlement as the company had announced that it will take measures to avoid scrapping vessels on beaches in the future. And the third is the Harrier, which is originally the Aid carrier, departed Norway in February 17, having been renamed Tide Carrier. Her documents suggested she was heading for repairs in Oman. However, soon after her departure, she suffered a mechanical failure, and the subsequent salvage operation by the Norwegian Coast Guard narrowly avoided a grounding. The vessel was detained, and then an investigation found that insurance for a demolition voyage had been obtained for a trip from Norway to Pakistan. Eventually, Tide Carrier was renamed Harrier and was sent to Aliağa in Turkey for recycling. In October 2019, the cash buyer who owned the ship when it was being exported was fined approximately $760,000. There are 2 other relevant cases. These test the ongoing liability of ship owners to injured or killed workers during the recycling of ships that have already sold. Both involve the same London law firm, Lee Day, who is reported to be acting on no-win, no-fee basis, apparently on the instigation of the NGO platform. The first case relates to a worker who in 2016 lost a leg and suffered back injury in Bangladesh while cutting the propeller of container ship Eurus London. The case was brought against the UK-based Zodiac Maritime. The case was not tested in court, but was settled in a confidential out-of-court deal. And the second one is in July 2020, a UK judge ruled that the widow of a man who died in a fall in 2018 while demolishing the VLCC Ekta, ex-Maran Centaurus, in Bangladesh, can pursue a compensation claim against the vessel's agent and sea broker Maran UK Limited through the UK courts. It was reported in The Guardian that if successful, in a future trial, the widow could be awarded up to £100,000 sterling in damages. My personal reflection is that whereas this is a colossal sum in many parts of Bangladesh, it could represent a small fraction of a typical London legal costs and may thus be designed to encourage another out-of-court settlement. I will now summarize the regulatory requirements on ships. Once the three conditions for entry into force of Hong Kong Convention are met, the Conference of the Parties to the Basel Convention will have to agree and decide whether in the review Hong Kong Convention provides equivalent level of protection and can thus replace Basel Convention as the legal regime for ship recycling. Until that happens, the administration of a port state may deem that a ship departing for recycling is subject to the Basel Convention and to the ban amendment if that state is party to it. These states I'm discussing now are not the European states, because the European Union states already are enforcing Basel Convention and the ban amendment to ships. In the meantime, the current requirements for ships are simply as follows. For EU flag ships, a ship flying an EU flag is subject to the European Ship Recycling Regulation, which requires it to be recycled only in a yard that appears in the latest European list of approved yards. The port of departure of the last voyage of an EU flag ship or its location at the time the decision was taken to recycle it have no relevance. The European Commission considers flagging out of end-of-life ships as a loophole that needs closing. And secondly, non-EU flag ships. Here we have three cases. First, a non-EU flag ship departing from an EU port or transiting an EU port on a voyage to a recycling yard will continue to be subject to the European Waste Shipment Regulation, which forbids its export to non-OECD countries. On the other hand, a non-EU flag ship departing a non-EU port on a voyage to a recycling yard is not subject to European regulation. However, there may be, possibly rare, occasions when the administration of a port state outside Europe deems that a ship is subject to Basel Convention and, if applicable, in their case, to the ban amendment. And thirdly, when a decision to send a non-EU flag ship for recycling is taken while that ship is in international waters and there is no other port of call before the ship reaches its recycling destination, the ship is not subject to any European regulation and cannot be subject to the Basel Convention or to the ban amendment. Final thoughts. In my brief overview of the regulatory requirements on ship recycling, together with the next presentation by Dr. Anand on the transformation of India's recycling industry, these should lead to the conclusion that the development and adoption of Hong Kong Convention as a global standard for the ship recycling industry has been a success. With most of India's yards in Alang now being compliant, with India's Ministry of Shipping having embraced the convention, with Bangladesh's Ministry of Industries working hard to develop the necessary infrastructure and culture of compliance in the yards, and finally, with a small but increasing number of yards in Chittagong upgrading and investing, those of us who have worked for the development and the establishment of responsible recycling ought to be giving ourselves a pat on the back. Unfortunately, it's not time for any pats on the back. Europe, through the European Commission, instead of supporting the improvements that are taking place in South Asia's clusters, with direct aid, with know-how transfer, and with inclusion in the EU list of approved yards that would reward and encourage a virtuous cycle of improvements, has instead disappointed and discouraged the yard owners who've invested in becoming compliant. It has also justified the South Asian yard owners who decided to ignore the call for improved safety and environmental protection in the yards. It seems that today's society is ready to accept, without critical judgment, the claims of self-appointed watchdogs, however biased and ignorant are their claims. In this way, around 3 years ago, the banking sector in Western Europe adopted its first version of the responsible ship recycling standard, which reflected the policies and rhetoric of the NGO platform. In the same way, the insurance industry listened to the siren song twice and imposed a Brussels type of warranty for ships going for recycling. P&I insurers may have been tempted to do likewise. Ship owners have been too busy with too many demands on their time, ballast water management, scrubbers, greenhouse gases, bad markets, etc., to take seriously the battle that is taking place for establishing the regulatory standard for the ship recycling industry. In the end of the day, you reap what you sow. The subjects I cover in this brief presentation are quite complex. The interested reader is welcome to download the second edition of my booklet, which describes the issues I addressed in much greater detail. I believe also that the notes of the presentation, the slides, will be made available. I thank you for your attention.
Dr. Michaelis, thank you very much for that very comprehensive presentation. The choices are not easy. I think, as I mentioned earlier, the regulation itself had a value proposition. Once we come to the execution of it, it has not been as easy. And the fear mainly is there is nobody talking about the voice of reason and what the facts on the ground are. As a result, especially those in Europe are being heavily influenced by the perception that EU ship recycling regulation is good and jumping on to this bandwagon, as you rightly mentioned, the banking industry, for example, the insurance industry. Whereas the right thing to do is to just open up their eyes and evaluate the issues based on facts. Fortunately for us, some of the owners have started doing that. And as a result, you see a big rush towards responsible recycling in India. And so we thought, since a lot of you cannot go to India, especially during these days, so we are bringing India to you. So as I mentioned earlier, Dr. Anand Hiramat is based in India. He is coming to us from Bhavnagar, which is right next to Alang. And his job is to explain things on the ground as we speak, and he has a lot of slides to show that. And hopefully that highlights some of the improvements that we were talking about earlier. So Dr. Anand Hiramat, the floor is yours.
Hello everyone. I have divided my presentation into two parts. My first part of presentation is going to cover the HKC SOC process, and it also highlights about the recent developments made in ship recycling yards. And my second part is going to talk about the responsible ship recycling program and the compliance monitoring at the ship recycling yards. In coming 15 minutes, I'm going to run 17 slides, 90% of which is all about photographs, which I have captured in my camera when I visit ship recycling yards for inspection of vessels. Currently, we have 153 registered ship recycling yards in India, out of which 120 ship recycling yards are operational. Among the 120 operational ship recycling yards, we have 80 Hong Kong Convention statement of compliant ship recycling yards. If you look at the right side of my presentation where I'm moving my cursor, you will notice that 35 ship recycling yards have achieved Hong Kong HKC SOC from the Japanese class, class NK. 63 SOC have been issued by the Italian class VINA, 4 by the Lloyd's Register, 11 by the Indian Register of Shipping IR class. If you look at the total certifications from different IX classes. And if you look at the number, if you look at the percent of ship recycling yards, currently we have 66 ship recycling yards in Alang which are compliant with Hong Kong Convention, and 10 yards are currently in the process to obtain HKC SOC from various classification societies. In addition, 5 yards have been audited by the auditors appointed by the European Commission to check the compliance with European Union Ship Recycling Regulation. Among the 20 ship recycling yards which have opted from India to be included in the EU list. It is to be noted that none of the none of the Indian yards have been so far included in the EU list of approved yards. The ship recycling Hong Kong Convention started with first 4 ship recycling yards in India. In December 2015, they obtained the certification from Class NK. And today, in July 2020, so in last 4.5 years, we have another 76 ship recycling yards which have obtained the Hong Kong Convention certificate from various classification societies. The process of obtaining the Hong Kong Convention certificate is quite complex and it's a time-consuming process. It usually takes 8 months to 12 months to obtain an HKC SOC for a particular yard. The process for obtaining an HKC SOC from a classification society, for the sake of easiness, for better understanding, I have divided it into 3 steps. The first step is development of an infrastructure. Second step is developing your human resource. And the third step is management systems. If this is a picture which you're seeing, it's a top view of the ship recycling yard, which has obtained an HKC SOC already. The first thing which you see in the ship recycling yard, which is compliant with HKC, is the impervious layer, which is connected with the drainage systems. If you see my cursor, I'm showing the drainage system along the periphery of the ship recycling yard. And it will have a designated, if you see my point number 4, where I'm moving my cursor, it will have a designated location for treating and cleaning the oily blocks which are generated from the ship recycling process. In addition, it will also have the temporary storage disposal facilities, among the major things which you see in the HKC compliant ship recycling yard. The second step is training of the workforce, which I call it as a human resource development. This is a very important thing where several internal and external trainings were conducted to ensure that the workers in the ship recycling yard know the standard operating procedures before doing any work activity. The third and important step is preparation of ship recycling facility plan, which is as per the resolution MEPC 21063, and development of ship specific recycling plan as per resolution MEPC 19662 guidelines. If you have to develop a ship specific recycling plan, we need an inventory of hazardous material report from the sellers, which should include part 1, part 2, and part 3 of the IHM. After these 3 steps are completed, the audit takes place. There will be several series of audits which takes place from a period of 8 to 12 months before issuing a HKC SOC certificate. In several classification societies, mandates the ship recycling yard to cut a particular vessel right from beaching to complete recycling before they even come for the audit. So the evidence has to be submitted to the classification society before they even come for the audit. On the screen, you are looking one of the ship recycling yard, and you can also see the workers working in a particular designated working area where the worker is performing a plate cutting operation in a ship recycling yard. Beyond the compliance from Hong Kong Convention, there have been several investments made by the ship recycling yards recently. One of such investment is purchase of heavy lift cranes, where several ship recycling yards have already demonstrated that without touching a single block of the single cut block, it is possible to recycle a vessel without making this block to touch an intertidal zone. If you look at the crane is directly lifting the block from the ship. In the next picture, you will see the land-water interface. There have been several complaints talking about the beach areas being washed by the sea water and all the contaminants from the ship recycling yard go back to the sea and its contaminants. But these particular jetties, which are being developed by various ship recycling yards in Alam, you can also see where I'm moving my cursor here. There's a proper drainage system provided where the storm water, oily water, and any kind of contamination which generates in the ship recycling yard is going to be collected and it is treated further. This prevents the leakage of any contaminants from the yard to the beach. In addition, if you see the right side of the picture, because of this jetty, it provides a direct access to the vessel from the yard. In this case, workers do not have to go in a mud or a sandy area to enter into the vessel. My third picture is about the hazardous waste management. The hazardous waste management is being done in a proper way, where before cutting off the ship, a dedicated hazardous waste management team, both internal and external teams, do recover the hazardous waste identified as per the IHM and submitted to the authorized waste handling. In the next picture, on the slide, you will see that worker is washing a oily block of a ship. So when the worker washes this oily block of a ship in a ship recycling yard, this is the oily water is being collected in the drainage system. If you can see my cursor, you will see that this drainage system is along the periphery of the ship recycling yard. Here, I'm pointing out to say that it is possible to recycle a vessel without allowing any contaminants from the yard to enter into the ocean. Adequate PPEs for workers. A basic risk assessment has been conducted for each work activity. On that basis, the PPEs, the personal protective equipments, were distributed in the ship recycling yard. If you look at the first picture, you can see the mask worn by the worker, which is the 3M face mask, which prevents the workers to get exposed to any of the contaminants or toxic gases. These pictures I have taken it from several ship recycling yards during my visit, and I have seen this recent development of proper adequate PPE to the workers. In addition, there has been a perception that all the workers in the ship recycling yards stay in shanties and all. But it is to be noted that, as you can see in the image, there is 1,000 capacity labor colony built by the Gujarat Maritime Board in association with the ship recycling industries. Currently, 20 dormitories were already being occupied by the ship recycling yard owners for their workers. In addition, several ship recycling yards have developed their own labor colonies for their workers. So these are the recent developments in the ship recycling yard beyond the compliance from the HKC. In my next slide, I will come to the second part of my presentation, which I'll talk about the compliance monitoring. When a ship recycling yard obtains the Hong Kong Convention certificate and a particular vessel comes for recycling, right from day one of pitching to the complete recycling, we under the responsible ship recycling monitor the recycling process and check whether all the compliance are met. I would like to add one more point here is that as on today, 50% of the green vessels are contributed by GMS. I mean, 50% of the green vessels which are delivered to India are by GMS. Plus, among the total vessels which are selling to India, 70% of them are going to Hong Kong Convention compliant yards. So if you can see this, there is a tremendous increase in the sustainable ship recycling in the last 2 years, which accounts to, as per our estimation, it accounts to about 170%. Our responsible ship recycling program is growing very fastly because of the experience we gained in the last 5 years by recycling 63 ships with 0 fatal accidents. We have been recognized by the industry peer reviewers. We have been awarded for our program. We have been reliable, and we have been audited by the several ship owners, and recently we have been approved by Evergreen as one of their recycling supervisor team. We also published the first green handbook on a practical checklist to monitor the safe and environment-friendly ship recycling. Last month, we conducted the 100th training program of the safety awareness training program at Alang and Chittagong, which we have been conducting from last 5 years at the ship recycling yards to develop to increase the awareness of safety. And this is at no cost to any of the yard owner. When I said we monitor the recycling process, actually we have made our own 18-step process in which 9 steps are before the vessel even comes to the ship recycling yard, and 9 steps are after the vessel comes to the ship recycling yard. In this process, we collect total 281 data points. When I say 281 data points, these data points are to check the compliance with health, safety, and environment when a particular ship is recycled in a ship recycling yard. If I go through all these points, it's going to take 5 to 6 hours for me or more than that, but I'm not going to go very much technical or detailed into it. I'll summarize in the next slide, showing the important or the critical steps what we do under the RSRP. Among the various steps, we prepare an inventory of hazardous material report in case the ship owners do not provide the IHM report to us. Second, we evaluate the adequacy of ship recycling facility plan. When I say adequacy of ship recycling facility plan, we check whether the given ship recycling facility has enough width to accommodate the width of the vessel in question. And also we check the compliances in the ship recycling facility plan. And in addition, we also check about whether the hazardous waste identified in the IHM report can be handled properly in the ship recycling facility. In the third step, we assist the ship recycling yards to prepare a ship-specific recycling plan. In the fourth step, we ensure that the identified hazardous materials are properly removed without impacting the workers and the surrounding environment. The fifth step is about ensuring that the ship recycling plan, which is prepared before cutting off a ship, is implemented completely. The sixth step is we provide the weekly on the monthly ship recycling reports to the owners. I am the main point of contact to the ship owners when they sell a ship under the responsible ship recycling program. So I submit the ship recycling, the reports on a weekly or monthly basis directly to the ship owners. The seventh step is we facilitate the ship owners to visit the recycling yards so that they themselves realize that what is currently being happened to their vessel which is under recycling. The final step is we prepare a comprehensive vessel recycling completion report, which includes Appendix 7, Regulation 25 HKC, which provides a recycling completion certificate. So this is, in a nutshell, I tried to explain about the responsible program. If you have to go through all the technical details, you are free to go through our green handbook, which is available in our website. Thank you.
Thank you, Dr. Anand, for that presentation. I know we're kind of running a little bit behind schedule. I will go straight to Nelson, but before I go to Nelson, the issue is we understand a little bit about the regulation. We understand what Hong Kong Convention recycling is all about, but then we are missing this very big part, which is all about headline risks and prosecutions and so forth. I must admit that thousands of ships are recycled on an annual basis. So it's not like these are the cases that are happening regularly. These are exceptions. But nevertheless, when exceptions do happen, it's upon all of us, especially us, to look at this very, very carefully and see if there are some lessons to learn, what happened, why, so that we don't repeat that. And our job is also to advise together with the ship brokers to the owners when they're trying to sell, to ensure that we try to mitigate some of these risks. So Nelson, if you can talk about some of these issues that have come up.
Sure. Right. Thanks for that. So I'll generally be looking at three issues briefly that's currently facing the industry at the moment. One is the inconsistent domestic enforcement and application of the BASEL Convention. The second will be looking and kind of putting it into perspective, the current legal and prosecutorial issues that, and headline risks that the industry is currently facing. And then thirdly, I'll just generally look at the recent ECTA judgment, which is, of course, has gathered quite a bit of buzz in the media lately, and which many in the industry are talking about. So when looking at the inconsistent domestic enforcement and application of the BASEL Convention, I think it's important to note that the convention itself doesn't include ships or offshore vessels or assets in its definition of waste. Rather, what you see is that in the preamble of the October 2004 BASEL COP V726 decision, it actually creates a dual classification whereby a ship may be deemed waste as per Article 2 of the BASEL Convention, and at the same time, it may also be defined as a ship under international rules. And really what this does, it creates certain key issues and questions in the industry. Namely, when is a ship deemed to be waste, and who qualifies as the waste generator, and which state is deemed to be the state of export. Now, those in the shipping industry will argue and say that ships capable of sailing under own power, that are fully insured, certified, fully operational, and capable of having manned crew on board, cannot simultaneously be defined as waste. On the other hand, you've got environmental groups mainly who strongly argue that the Basel Convention should apply to all forms of waste, regardless of the object's capability or being able to operate, or the possibility of it being being economically reutilized or having any sort of economic intrinsic value. They also argue that it's irrelevant where this hazardous waste is located on the vessel and the quantities of this waste on the vessel for the purpose of determining whether a ship is waste. And so really what you're left with is kind of uncertainty for those countries outside of the EU when it comes to determining whether a Basel Convention party state will declare a vessel as waste at the time of export. Now, we know that what triggers the enforcement of the Basel Convention will be the intention, when the intention is formed to recycle the vessel. But this happens despite this dual classification that exists, or that will exist at the time that the intention is formed to send a vessel for recycling. So what you really see then, or the end result, is that there is no uniformity or consistency on whether parties state to the Basel Convention will treat an end-of-life vessel as waste. And also in practice, what we see is that there's no uniformity or consistency in terms of the value of financial guarantees that an exporting state might impose on an exporter, as well as the timeframes that one can expect when going through the procedures and process of permits and transboundary applications, which we know can take months. And in fact, we've actually seen in practice where this dual classification will conflict with one another. So for example, you may have a seagoing manned vessel that's going for recycling, and the exporting state may require the pre-removal of certain hazardous waste items on the vessel. But as you know, the ship, if it's being manned and is sailing, is governed by other international regulations, for example, such as SOLAS, which would require certain minimum mandated safety standards in regarding the vessel safety and its operation and design. So for example, you may have thermometers that have mercury contained in certain machinery or on the engines. And these hazardous items cannot be removed without simultaneously placing the exports on the vessel in breach of SOLAS requirements or even flag state requirements. Then briefly just going on to the next issue, which is really putting it into perspective, these current legal and prosecutorial issues and headline risks that we're facing. And really what we see in the industry is that there are two main types. One is obviously these prosecutions that are coming out of Europe from the EU authorities for breaches of the EU waste regulations. But what we're finding is that really it's mainly coming from Norway and the Netherlands. And these authorities have taken, and recently really, an extreme and highly aggressive approach when it comes to prosecuting these types of cases, where they're really attempting to extend their prosecutorial reach, not just over ship owners, but as we've seen over well-known P&I clubs and even marine warranty surveyors. So for example, we've seen in the recent Harrier case where a well-known P&I club was investigated by the Norwegian authorities, and where a well-known marine warranty surveyor actually successfully defended the charges laid against it by those authorities. And then we see the second type of claims really recently coming up, and these are compensation claims from work injuries or deaths in another jurisdiction. Here, the claimant's often represented by UK-based law firms on a pro bono, i.e. for free or a contingency fee basis. And these claims are filed out of the UK courts, where these claimants are represented by these UK human rights-based law firms. And so currently we know of two main cases. One, the Eurus London, which was settled out of court, didn't make its way to a final judgment. And the current ongoing case of the ECTA. And so we see that although these claims are initiated out of the UK, none of them have, well, none of these cases have yet to be conclusively determined by a UK court. And we often see that settlement is seen as an easier option rather than seeing the entire case to its end. And so when it comes to these headline risks, or the headlines that report on these types of cases, we tend to see that these headlines can be quite aggressive and can be, and sometimes are actually driven by certain groups that tend to push a particular narrative. And this tends to have kind of a wider influence on the media and the general public perception of the industry. So what you find is some of these active groups often quoted or referenced, and sometimes these statements can contain certain misinformation or general statements and assumptions that are not really based on factual realities. So of course, as a ship owner, you're faced with these headlines, and these articles do pose and can pose a reputational risk. And often settling out of court is seen as the easier option, in order to avoid the potential negative media exposure. So then I'll just briefly and quickly move on to the third issue, which is the recent case that's been, getting quite a lot of buzz in the media lately. I think if there's one key takeaway to take from this case is that, we see some headlines saying that the court has ruled that the seller owed a duty of care to the claimant. I think we just need to be clear that it was only actually an interim ruling on a summary judgment application, where the judge deemed that the claimant's case was not necessarily bound to fail. And so, as many know, this is a tortious claim or claimant delict. And the question really is whether the seller owed a legal duty of care to the deceased worker. And in my view, I mean, when you read the judgment, it seems like the judge, he accepted and acknowledged that the cause of the worker's death was the actual falling of the worker from working on the height on the vessel. But what he held, though, is that on a broader purposive approach, the accident resulted from a chain of events that led up to the vessel being grounded. So importantly, he makes it clear that the vessel itself was, the sale of the vessel itself was lawful and legitimate. But he doesn't make any actual definitive conclusions as to whether the seller should be actually held legally liable for the tragic circumstances that happened at the yard. So at least when you read the judgment, it's clear that the judge had decided that, at least from the seller's perspective, it was foreseeable that the vessel would essentially end up being recycled in Bangladesh. But to be clear, he didn't make an actual conclusion as to whether the seller was or could be found to be the actual cause of the worker's death. And so I think in my view, when looking at the judgment, I think the difficulty in trying to hold the seller liable and responsible here is that really what the court would have to do is two things. One is it would really have to decide and hold that sending a vessel to Bangladesh is guaranteed to result in a fatal death or an injury. And secondly, what it would really do is ignore the other active players in, if you like, the entire chain of events, and really the yard's role, and for example, the health and safety measures and other circumstances surrounding the case. So I'm not sure if these are sustainable arguments. I know, for example, there are legal commentators out there which have said that the claimant's prospects of success do seem to be quite low, and so it remains to be seen how the UK court does treat this case if it does end up going to court. And yeah, so we should just watch the space.
Thank you, Nelson, for that. So before I go to the questions, and we have several of these questions that have come in, Nelson, you said the nuisance value. Does it help? Do you think, does it help? And Arjun, you may join if you want, but let me ask Nelson, that if these cases, because these are two cases have come, which are quite different than the cases Dr. Michalis reported. These are more litigations about worker injuries and two substantial companies out of UK. So the first company settled, and you think if this case were to go to court, the chances, as you said, legal commentators saying maybe they are low. would that reduce, or you think by settling, I think Dr. Michaelis alluded to that as well, that will just propagate more and more cases? What is your view on this? And it's a hard question. Right?
Yeah, it's a look. I think so. Of course, I think the easiest option is obviously to settle, but I think again that there's also risk on that sense, in that you may actually end up opening the floodgates for these types of claims where the arguments may not be legally sound, but knowing the reputational risks and the kind of media attention that could be used to pressure owners, that I think could be dangerous if, for example, such a case is not really decided, or if there's no kind of definitive conclusion drawn onto whether such a claim would be successful. So I think there could be a risk, or there is a risk and a danger of these types of claims, being filed really just maybe to pressure owners into settling. But as the judge said, it really is a developing a new area of law, and especially when you're looking at a tortious claim, there are kind of a lot of issues and policy debates, which would have to be looked at, and it would be very interesting to see what the outcome would be if this was.
So Arjun, because this is a question asked by Mr. Craig Jalal, who's editor of Riviera Maritime in UK. So I mean, he has basically talked about this case, and he concludes by asking the one question, saying, how will this judgment impact, 1, the ship owner, 2, the cash buyers, 3, residual values, and 4, demolition market in general? So Jamie, I'm going to ask you about 3 and 4, but before I come to 3 and 4, so Arjun, how does it impact ship owners, and 2, the cash buyers? And after Arjun, maybe Dr. Michaelis, if you can tell us, what do you think will happen with this, Arjun?
I think to begin with, that taking what Nelson said, that this is still just an issue in summary judgment. So it would be quite early to speculate that if there was liability foisted on the owners, what it would affect, how it would affect cash buyers and sellers going down the line. But assuming that the low chance of them succeeding actually does happen, it just requires that there needs to be more vigilance. And then we need to have corresponding clauses in the contract where you get into the issues of bringing the owners more involved in identifying where it is that the vessel is going to be scrapped, what the facilities are, what the regulations and how the practices in the yard are being followed, whether it's going to India, whether it's going to Bangladesh. Because one of the key issues to note in this judgment is that it proceeds on the assumption that it is a universal truth that Bangladeshi labor practices are bad. And that was something that was done on the basis of unilateral expert evidence from the NGOs and from those environmentalists. In the trial, eventually it's going to become an issue. Expert evidence on the other side is going to be laid down as to what the conditions of the Bangladesh yards are. But eventually it is going to have to become, the owners are going to have to become more involved in identifying what the yards are and what their facilities are. And this brings us to the question of, therefore, when do sellers start evaluating that they need to start recycling vessels and therefore calculating their residual value? We've seen that decisions regarding recycling are taken at the end moment. Suddenly, if the market is high, or suddenly if there have been issues with the vessel and just a decision is taken, okay, let's do it. But it's an evaluation that needs to be done before, so that you identify A, what regulations are applicable to you, B, what type of procedures you need to do. For example, if it's an FPSO, there's so much more cleaning involved and all these kind of things. And then you start identifying, okay, therefore, which is the perfect yard that I need to go, how much time it's going to take, what my last few voyages and when they need to be. And then accordingly, you'll be able to gauge the market fluctuations and arrive at your residual value. So I think if it does happen that eventually in the suit, they do find that there's a duty of care, then it's something that owners and cash buyers together need to start involving in their contract. And it's something they need to it's not something that can be left to chance. It's something they need to account for. I think you're on mute.
I'm sorry. Yeah. So I think, so just to recap, so what you're saying is, Arjun, that they need to plan ahead. You know, the owner can't simply come into the market and say, here's my ship, and give it to a broker and say, give me the best offer, and within 24, 48 hours, you have a sale, which we could do in the past, but maybe especially soft targets. I call these soft targets owners in UK or EU, maybe they need to have a planned policy. And that's when the role where Mr. Jalal says, how does that affect the cash buyer, that we as cash buyers have to become a little bit more involved rather than all just doing a transaction. And there has to be an expertise, which we are trying to create, so where we can be more as a guy working with them. Then comes the main, yes, Nikos, did you want to add anything to that before we talk to the money part of it, the residual values?
I think Arjun Mittal explained it very clearly that the prosecution in both these cases are based on the subjective view that Bangladesh is inferior. Whereas it could be that Bangladesh has inferior practices to some extent, or many of the yards, but not all of the yards. These kind of prosecutions are creating pressure now against Bangladesh. So Bangladesh is going to, some people will avoid going there. In a sense, that also creates a pressure to the Bangladesh government to take action and move towards the accession to Hong Kong Convention and to the upgrade of its industry. It also creates a pressure for the entry into force of Hong Kong Convention. For me, all these things are good, but they are happening for their own kind of purpose. Thank you.
Thank you, Nikos. Jamie, you want to talk about residual values then? What will this do? And yeah, go ahead.
Yeah. So I mean, I've been seeing increasingly a lot of owners trying to sell their ships for HKC, and that means India. You know, whether it's NK Arena or the full range of HKC yards. I mean, generally, in terms of price, you're not looking at really much more than 10% to go for a full range of HKC recycling compared to if you're going for EU. I had an owner call me earlier this year saying he's got an EU flag vessel that he wants to sell as is Far East, and can I give him a deal, you know, for EU approved yards in Turkey? And actually, because of the lightweight of the vessel and the location, we found that his asset, his vessel, became a negative. It became a liability to him. It actually cost him to recycle for EU. So, you know, in terms of the standards for HKC in India, as you've seen from the previous presentations, you know, you really aren't discounting your vessel that much if you are going for full range HKC into India.
325, let me know. So I think if I can recap, so it's basically ship owners, cash buyers to work together. Residual values may reduce by 10% if there's a flight towards certain yards, HKC yards, whether there is one yard in Bangladesh and or to the Indian subcontinent. And what's happening to demo market would be more towards, you know, flight towards qualities to some of these owners. We do know owners who have in the past who have not gone to HKC yards have now started asking for HKC yards. And these are owners not just in Europe or in UK, but these are also owners that are in Asia. And do you know, Doctor, because there's a question here, whether we're gonna see more this thing HKC certified yards in Bangladesh. Do you have any, because I know you work there as well. Can you tell us a little bit about this?
Yes, especially we can see in coming years, more yards applying for the HKC SOC from Bangladesh, mainly because if you can give an example, like Norwegian government is working with IMO, and in the Sensilex phase 2 project, they have come up with a very beautiful plan of training to the workforce and setting up of an hazardous waste management facility, which is a key point for Bangladesh hazardous waste management facility. So with that, and as well as with the PHP setting up an example where they have proved that, you know, responsible recycling or green recycling is possible in Bangladesh. Keeping that, I can see in coming, let's say, and in addition, and Bangladesh also had showed an intention to ratify HKC in coming years. So keeping that, it's yes, Bangladesh yards will have more yards because in coming year or so, all the yards in India will be HKC compliant. So next decision is in Bangladesh now.
So I do know there are yards that have applied for HKC as a statement of compliance certificates. They're working towards those in that direction. Do you know how many these are? These are 4, 5, 6. How many approximately?
As far as I know, as on today, 3 yards are already applied to them, and several yards are already in pipeline. They are investing in infrastructure. They haven't approached the classes yet.
I have a question that has come from one of the bankers. And the question is, how do you best respond to compliance departments of big banks about the reputational risks with ship recycling? So this is coming back to, big banks who, again, I feel are soft targets. Now we know Citibank initiated the Poseidon Principles, which has not to do with ship recycling, but generally about sustainable shipping. Maybe Dr. Michaelis, I don't know if you can answer this. How can they avoid the reputational risk?
Well, first of all, the initial efforts of the banks to set up a system for ensuring that their clients always use responsible recycling was childish, to say the least. It was ill-conceived. It demanded adherence to European ship recycling regulation. Now we see that there are only 6 yards in Turkey that are approved. And there are many hundreds, there are thousands of European flag ships. So the idea of having to channel all these ships to even international non-European flag ships to European regulation solution is naive. It took a long time. It took about a year for these banks, the group of banks, Northwest European banks, to change the system and say Hong Kong Convention or European regulation. Now, for me, that is not a serious effort in improving standards. If you have serious ideas, then you find out what it is that you are trying to influence. Here, these people, unfortunately, had not even found out what the difference is between EUSRR and Hong Kong Convention before they started demanding it. So my question to them is, are you serious about what you are asking me to do?
Let me try to respond based on my experience. I mean, we have had banks who have made trips down to Alang. Basically, my recommendation would be that, first of all, if you understand what the risks are, first definition of what these risks are. And then again, having what Arjun was trying to say, some kind of a planned program or a strategy. I know Standard Chartered Bank has gone ahead and done some proactive measures in that aspect as well, where you actually go and study this, do site visits. I have had banks from EU, Scandinavian countries who have taken the policy, made a decision that they're gonna require their clients to recycle their ships based on the Hong Kong Convention. Basically, you will lead a policy. The question is whether you gravitate towards EU ship recycling regulation or the Hong Kong Convention. But the bottom line is, one risk mitigation way is to understand the risk and then come up with a policy that you can justify to your stakeholders why you're doing, what you're doing. Whoa, too many questions. I have to ask this question because it is again very topical because it's coming from UK. So, and with UK coming out of the EU, what is your legal aspect for, say, a foreign flags vessel port of discharge prior for recycling in the UK, where it should legally go? And if a UK flagged unit is sold worldwide, should it still only be resold for recycling at EU approved yards? And the other question which dovetails into this is saying, with Brexit, the UK will have to have its own list of approved yards. Is there any hope that this might include Indian yards based on class SOC inspection? So we have basically saying with Brexit and UK coming out, what are the implications? Because you are our regulation expert.
Well, in January, UK will be out. Until January, UK has got both European, the ship recycling regulation and waste shipment regulation. After January, I expect, but that is to be confirmed by maybe Chamber of Shipping, UK Chamber of Shipping, that the ship recycling regulation will not be applicable to UK flagships. So UK flagships will not have to do that. However, I expect, again, it's my guess, that any ships leaving UK ports will be subject to the continuation of the waste shipment regulation, because UK will have to change thousands of rules and regulations, and that's not automatically done. So it will take a long time for UK to decide what to do. I don't think UK will impose on its own ships a European ship recycling regulation, nor any standard until Hong Kong enters into force. But there is a lot of guesswork in my answer.
Thank you, Nikos. Jamie, there is a lot of questions on cruise ships, because we know as of now there are about 15 vessels that have come into the market in the last month or so, mainly a lot of cruise ships. And some of these are in public domain, some have done privately and offshore. As a trader, if I have a cruise ship today and I want to sell it based on EU ship recycling regulation, what are you going to tell, what are you going to advise me?
Well, I think the last Carnival cruise ships, they've all gone for EU recycling into the 6 yards in Turkey. So if you're selling for EU recycling only, you really are limited to those yards. And in terms of the other yards outside of Turkey, I don't think the capacity, if you're talking about, let's say, a 20,000 lightweight cruise ship, I don't think the capacity is there to take those kind of ships. These are complicated vessels to cut. I've done several cruise ships previously. You have to be aware of the permanent ballast, the insulation, the asbestos on board. Of course, there are a lot of decks, a lot of cabins to cut. So these are difficult vessels, and you know, doing a proper IHM and sending it for recycling is, you know, it's a complicated matter. So you only really have those 6 yards in Turkey, and I think a lot of them are now full up because of, you know, the sale of quite a few of these Carnival ships recently. So it would probably take those yards clearing out before you deliver to those yards. And whether you'd sell it on an as-is or a delivered basis into Turkey, that would be an economic decision as well.
I think what I can say to the audience is that most of the ship, I don't see any of these cruise ships that have gone to India. I have not seen any of these cruise ships being recycled to any of the European shipyards, except the ones that I showed, that the Italian, where the owner has paid the yard to recycle the vessels. So if the evidence shows that right now you cannot recycle a ship within EU, you can recycle it in Turkey. Having said that, the Turkish yards, I know in the short term are full. We had the owner asking us when they can wait. We checked with the yards in Turkey. They said we need to wait at least 2 months before they can take the next one. So there is now almost a waiting period. So what Dr. Michalis said in the beginning, saying there's enough capacity, evidence shows it's untrue. There isn't enough capacity to recycle. So there is, right now at this stage, demand for EU ship recycling exceeds capacity. So there is pretty much a waiting list for these vessels. Folks, I'm sorry, there are just way too many questions. I thought we'll have more time to do it. Last webinar was for 1 hour. We extended to 90 minutes. We are still running out of time. So what we'll do is we have your questions. We'll respond to this, you know, on one-on-one basis. If I may recap, should we quickly show the poll, just see what the results are before we, and this comes as a surprise to me as well. In your opinion, which of the following has benefited from EU ship recycling regulation? Obviously, majority say EU ship recycling yards. And if you scroll down, can you scroll down? None of the above. In our view, there is correct. If there is a correct answer, the answer is none of the above. It's not EU ship recycling yards, and we can have a different debate altogether about who really benefits out of this. And the reason, as I said earlier, there's just not enough capacity in EU that these ship recycling yards are benefited. So these are outside EU. Which has done a better job? We agree with this. It's not a competition. I have from France an opinion saying there is no competition between HKC and EU ship recycling regulation. I agree. We highlighted the differences. Both are trying to do the same thing, but in fact going differently. And Dr. Michaelis said it quite well, why the HKC has done so much more towards ship recycling, whereas EU has not. Are EU ship recycling facilities better than SOC yards? That was, again, the answer is no. This is quite an educated audience here. Once again, on question 4, on the 3 R's of waste, reduce, reuse, recycle, seems like HKC is doing better. Is beaching better than lending? The answer is a very loaded question. The answer is no, but if you look at it, ships that are beached in Turkey are also beached, except they're known as lending. So if I can conclude, just a concluding statement. I was thinking about it. What has happened to EU ship recycling regulation, and especially during the COVID-19 era? To me, EU ship recycling regulation is like a hurried vaccine that was launched based on biased data. Once it was launched in the real world, we have learned it not only fails to cure the patient, it also has negative side effects. The question to those in EU is, what would you do if EU had introduced such a vaccine? Please think about it. This is a personal question to all of you. You may have good intentions. The results, evidence shows, and we can debate this for 3 hours, why the evidence shows differently. The second conclusive statement that I can conclude with from our experiences, that owners and capital providers should not be afraid of the dark. A lot of these things that have happened is because there is a very kind of a one voice that is saying one thing consistently, and there is no counterpoint, real debates that are happening. And that means bankers, the capital providers, ship owners, soft targets, listed companies, they're afraid of the dark. They're afraid of ship recycling. My point is, all you have to do is turn the light switch on. Like those of you who have young kids at home and the kids are afraid of the dark, you turn the light switch on. Once the light bulb goes on, you will clearly see that Hong Kong Convention is the right regulation to follow. There is a road ahead that shows which way to go, where you can do responsible recycling. In the meantime, capital providers, you should look closely at the residual value of your EU flagged and perhaps EU owned, vintaged, and perhaps even middle-aged assets. Because what EU ship recycling regulation has done has created a very strong negative impact on residual values. And so that's the financial implications. Again, thank you all for attending this. We'll continue talking about various issues, but thanks for joining us. Have a good day. Thanks, bye, and stay safe.